NSI. Law, and what when you mammy free Supreme Court 4-1 decision, a woman a buy. If I were Kevin Taylor, the other court down one more a far new warrant, once some arrest warrant, once some. It will say a dear banana if you are Sebeche.
Look, 4-1 split. Just say judges in Ankara, they disagreed among themselves. Yes. They disagreed among themselves because are unanimous.
Okay.
4-1 no. This will be a test. Ruling Nankasa as a car. A test for law students. They will be reading it and they will tell us why the one judge did not agree with the others. And it means that Wohano as commentators. Yes, so likely we are going to disagree.
Now, my law, Mammy Musadi, dear Matia woman said decision no majority of the Apex Court of the Land, the Supreme Court judges, you know, Agent Swan say, necessary a man of quine, a man Kayetina Sam, Ewo, and San the beer. Yeah, committing to contempt or man arrest warrant no near the idea. Benny person or my why not? Yeah, man arrest warrant. I guess you ten ones and an arrest warrant.
And only accept no. And even themselves, the judges disagree. You say no, it means no court can order a warrant to arrest anybody anymore. Since answer was no. It means bench warrant now. One court issue for you to be brought to court is now being rendered nugatory and also useless. Because the position of the law, they say, bench warrants. Who if you read the act, the court act near the and the act now, the court can issue bench warrants when you don't come to court. It means come to court, come and tell us why you are not guilty of XYZ.
Summons will be a criminal summons will be a come and show cause.
Yes. So there's nothing wrong with say we issue warrant for you to be arrested. It doesn't mean you are guilty of any offense. Yes, you are convicted. See, this is the distinction. Then it makes sense why you did not hear him before you convicted him. The man has not been convicted. The court wants him to come and then show cause why he should not be convicted for contempt. It's a warrant issue day to day against everybody or anybody who fails to come to court. And they say police officers in a court not asking for bench warrant. It means that the court now cannot grant it.
Oh, sanity.
Was it?
But it will be a dangerous precedent.
It is dangerous. I don't think the judges now they could not agree. The judges themselves could not agree because some of you say, for you to come to court and you say you are not coming, the only remedy available to the court is to issue a warrant for you to be brought, which is what has to be done. Otherwise, you are not coming. It is issue warrant. It doesn't mean say you are guilty of any offense. The court has not said Kevin Taylor is guilty of any offense at all. What the court did, they say, was a certain video has been brought to the court's attention of somebody insulting the court. And therefore, produce him before this court to answer. That's the underlying word. To answer to the question of why he should not be committed for contempt. That is what we call police natural justice and or term pattern. The court.
Law, Mr. Kuta, a Criminal Other Offences Act procedure, no 1960.
Correct.
Now, what kind section 71 now? Well, it was the issue of warrant of arrest. A warrant may be issued at any time before or after the time appointed in the summons for appearance of the accused, although a summons may have been issued.
Exactly.
Now, and no, two no swap or say A warrant shall not be issued under subsection 1 unless a complaint or charge has been made on oath. Now, over 72 no was a summons disobeyed, where the accused does not appear at the time and place appointed in and by the summons, and the accused personal attendance has not been dispensed with under Article 70, the court may issue a warrant to arrest the accused and cause the accused to be brought to before court.
See, in a way, no, the court has now made Act 30 that provision already.
Act 30, yeah.
Useless. But you see, courts are not, they are subservient to Act of Parliament. The law is made by lawmakers, and courts interpret the law. That is the position of the law. And see, in interpreting the law, no, it's almost say he needed to be given a hearing before a bench warrant is issued. Meaning that it's a police officer called court. Not say, a year, officer Unia a year. And so back, many people who know. But when you're not hearing before you get bench warrant. Meanwhile, if you look at this warrant, that's an issue here, or Koko Kwasi and right. What's it? Bring him, he has to be produced before the court to answer. That's what we call natural justice. Audi or terror party rule now. After was it, come and answer. So, the judge got it wrong. He hasn't convicted KELVIN Taylor. So this is going to be a very fierce debate among law students.
Because they say no, we'll be to be court to see a issue arrest warrant.
Because now the judge, the Supreme Court is give him a hearing first. Give him a woo,
I just so confused.
How do you give him a hearing? I don't think the judges know themselves, they could not agree. That's why I went for one. Because how do you give somebody who is on the run a hearing first?
Now, Attorney General no betting to review. Meanwhile, I said no one
Attorney General was the interested party. You see, he was served with the processes as an interested party. He ought to have gone and argued against it. Oh yeah, another one.
I said no one to me. I'm calling him.
It means that what by ambassador, you are free, you are above the law.
Now, me ba me bo say ama case na substantive case no ankasa na na ese oba na ye betie na no asem no aye moot ana say
yes, it's moot. Now he is no longer required to go to any court.
Oh wow.
To answer anything. Because the warrant has now been struck out. It means that now there's nothing for him to go and answer. Nobody is asking for him anymore. Because you see the practicality of this, and I say it's impossible for you to give somebody a hearing before you should issue a warrant for his arrest. How do you give him a hearing before you issue a warrant for his arrest?
I see. Me patcho meet you.
And also, it's an act of parliament.
Yeah, an act of parliament, yes, sure.
Yes. Hey, where the person fails to come to court, issue a warrant. And the police for any warrant, or all police warrants will now be set aside. It means that now, Ken operator, the warranty has to be set aside.
Ah! Anybody bet me a use way? But yes, case be so adjudicated on its own merit.
Matter. When the Supreme Court speaks, they set the law. They have now set the law. Say, for you to even issue a warrant, you need to give the person a hearing. That's what it means. If the OSP warrant no issue, it means that it's now a nullity because he hasn't given Oforiaka a hearing. It is also a judgment. No.
Wow.
Master, we are in for a big storm.
Wow.
All warrants issued before yesterday are now going to be questioned because you did not give the person a hearing. Now, how is that practicable? The practicality of it is that it's not possible for you to give somebody a hearing before you issue a warrant for his arrest. It's your jubilating now, they don't know it's as one. It's a police officer to be my man, because there's a whole fugitive, there's no more hearing and a court are granted. That is what will happen.
Eti obi betimi arane to the Supreme Court. Ebra ye issue arrest warrant the amano say man hearing answer.
That's what it means. Of course, our authority original. It original so at the Supreme Court, depending on the panel, we decide to set this ruling aside as wrong. Okay. Supreme Court can change its ruling anytime.
Right.
So what is the mechanism?
Me too, pa.
So the another bench will say no, we got it wrong with this ruling. We are setting aside. Otherwise, now it means that no police officer can go to court and apply for bench warrant. Because if it's granted, it means that it's a nullity because you did not give the person a hearing. That's what it means.
And Act 30 no so a procedure, a choir, as of us.
No. My yes, my year cases are police officers arrested my client, put him in prison, police cells for 13 days. I sued the police, and I quoted this act, and the judge agreed with me. Hey, the purpose of bench warrant is not to go and arrest the person and put the person in prison. No, you arrest him and bring him to the court immediately. It's all that warrant against Kelvin Taylor was supposed to do is that he was supposed to be arrested, brought before a court, and the court will discharge it. See, it is there second no back room has 2nd July to say Obama. Almost airport. No, the court, not court to discharge it, bench warrant. There was no need for even Supreme Court to them to take this case to the Supreme Court.
Okay.
What is the mechanism?
Me too, pa.
Because bench warrant, it doesn't say put him in prison. No. It just says bring him before the court.
Oh, okay.
That's all it means.
Yes, yes, Cochin Cotum, Debbie.
Debbie. Arrest him and bring him, produce him. It's not a commercial airport. Maybe I'm here. That is here. Academy at Chino Airport. They had at the court. That court are granting the bail. Finish. There was no need to go to Supreme Court. They say what? Is the Supreme Court is changing the whole position of the law now. Meaning that now ordinary bench warrant issued to police officers is now a nullity.
Wow.
Yes, and so the Supreme Court better assist position.
I see. Now, been more than your bomb wanted. Nebia, you don't pictures about days. And
the market was say can operate a case. Now it means it's a nullity because the warrant was issued to these people without hearing from Ken Operator. Kelvin Taylor's case has now changed the position of the law.
Okay, all right. Now, Lord, Mamma Samra, and also another landmark a year by any say, Dr. Kwabnadu 4 and 7 others, so no, a jai woman, na issue near Sikabia, na a year, my dear, a could do one. Aha, Sikabia, a could do one, na yes, woman, and she says, one 60%. And a man who can see Jawom. Plea bargaining acts, no, saying a kafa sad any day is seen rain.
Nana, there is no law in Ghana that says who 60% with Jao. There's no law. What the Attorney General was saying is a lot of crap.
Why?
There's one court to law. The law, no position of the law, say, even under the Court Act, you can enter into an agreement with the prosecution to provide compensation in lieu of going to prison. But you have to be convicted first. Aha. It means to say, so we are Abayasika, and after through certain circumstances, Abayasika becomes a financial losser. You can enter into an agreement and say, oh, I'll pay X. And if it's acceptable to the state, the state is okay, pay X, but you have to be convicted. It's not available to somebody who is not prepared to be convicted. I don't know. I told SCN.
Yeah.
He agreed to pay a certain amount, which was accepted. It's more like terms of settlement. But if you fail it means that you have to. So Etienne was convicted first, and he was given an opportunity to pay. Failing to pay, then you go to prison.
Okay.
That is what ended Etienne in prison.
Oh, okay.
There's no law. And I was quite reading it. I was really quite curious to see which law he was going to cite. Once I did law,
one court to authority,
one court to read.
Mati.
And one say with 60% and it's blah blah blah.
Let's say you can't put something on nothing. So in absence of any law like that, you know, you then not come by that 60% at the end.
Friend, nebusano. Yes. We was always maybe over. He is best. But you see, the truth of the matter is say NDC people who were charged, the lawyers that were involved, they happen to be the Attorney General or people working in the Attorney General's former office, the Deputy Attorney General or Deputy Attorney General's former office. Now they find themselves in government. They are going after their former clients, which is what we call conflict of interest. You are not allowed to go after your former clients. So they are in a difficult position. Say, how do I now represent the state against my clients? And until I'm finding a way to make all the cases police cases. You know, I'm discontinuing cases. You know? Because you are not allowed to go after your former clients. And Dr. Dufo, all the other ones, they were represented by either the Attorney General himself or their office.
You can't go after your former client.
Correct. That is the position of the law. It's like me now, Kwame, we are my client. I cannot in the future go after you.
Your case be and I similar no behind.
I'm not allowed.
Oh wow.
That is why. Until they find themselves in a conflict of interest. So they need to find a way to overcome that conflict. And no matter that, any end up cases, end up. That's the truth.
I see. No.
You know, woman, my catcher. You've been a Attorney General, and I will Kwame. We are my former client. Why I'm not allowed to touch your case because you've been in a position before. I confiding in me. I know all your vulnerabilities.
Yes, Sadia now be evidence. Okay.
I know all your vulnerabilities. So Pamno, don't go after your former client.
Wow.
And one more final one said they are in conflict. And on my head, they drop those charges, finding flimsy excuses which hold no water. Yes, I call you say. I said, refer those cases are one more than in Sakano. Emma special prosecutor. Because that's what the law says. And this one is important. He's a special prosecutor. He's not on his own. And people are mistaking the special prosecutor independent. No, they are wrong. The act says he can only act when he is authorized by the Attorney General or Parliament. Authorized by the Attorney General or Parliament. But once he has to be challenged.
Baba, there were other subsidiary legislation or what?
I don't understand.
Sir, there were other acts be a Parliament a pass it. And I'm fancy on one special prosecutor. Say, I am rather batana, Juma.
Yes.
Aha. Always a special prosecutor. Operations Regulations 2018 LI 2374. Yeah. If you want to be in them, I'm finding a Juma. Without recourse to the Attorney General.
And to say what? You have to go back to Attorney General for authorization.
Oh, wow.
Because in the airline, simply about procedure, how to go about things. But you have to go authorized. No, Attorney General. Finding himself in conflict, the SFONSA, or refer those cases to the special prosecutor as an independent person to take over. That's what they are saying. That's what the Attorney General ought to have done. It will be someone to overcome, and he's not prepared to give it to the office of Attorney General there on discontinued cases. And then when they say, we cast out home, that's, we follow. and a man who's a Ghana, you need that to be a.
I seen if you are vice president for Tano, a demand on young Cotton, the Capintilla by no tea. National security for now, airborne home by, and the Capintilla or national security protection. As to why nobody knows Capintilla or national security protection. I mean, okay, Oba Hona Noti, and I'm born home by Naja, Kakaka, modern court as a court I bench and free so. But for her, I decision here by and this in the judiciary again. Sometimes, what you want to say, the judiciary and some banner a war more, the be on the judiciary as a more as someone said, the Biaba. From judges there, then say no commenters the lawyers for commenters the from judges there, but the bias and bufro. Obia afa konya akeka nsem bisi ya da tutu judges ho. Your friends on no me no. Court say man me yina no. Because Supreme Court no under Article 132 of the 1992 Constitution had a supervisory jurisdiction over the High Court in the court transaction. High Court na no boy no. He has squashed it and so aba asema to agu. Until Kevin Taylor the back court ever be in and one. Nanka heading. About the panel base. But that's the reason of the Supreme Court. A judgment Nanka said my until we entity at the home. The cast a judgment in the banet me kind for one. Then the reason in Tia Supreme Court no a cabati at CBB almost a natural justice say Kevin Taylor was not head. Because answer be for an answer bim no. And so teeny panel no massem. Now as soon as he quite the born in ye. No, not so kafa hunye. And so there and there. On fan unkodi and I say, Yenchinaso. But Kevin Taylor now, Mamma can say, be a quite and some yanko merit of the case, no, court and uncum. Tiama, I say, Siciano, confidence aba, ultimately, Painibia operatum organa, because at the court Bogu. Say, I'm bolding for. Say, I bolding for Musu Sebisia Ghana out here, we are there, Yachua. Now this can be caught. Now I could do the aka. Since you're nine body among for corruption is animal one day. Ghana, the M say, Yenny agency PC Chasso. And second, I Kevin Taylor did the amount for them. Now the amount for them or Ghana hack can some and some kind of the offer. Ghana will be any. You know, ye will be the who say a political decision. I'm the decision that the so or the Supreme Court, like I said, yeah. I didn't say discharge the ball in few noon of a few noon. Apparently, in Ghana or by a national security for and protection. Vice President Fee. No crocodile. Who is Kevin Taylor and so called that vice president fee? And then say who's to know vice president fee? Kevin Taylor, vice president and who's to know. Tell the Ghana would dear Temwa, Okra, oh yeah, hero, would now but said transit, dear man for them. As him Ghana ha. I didn't check. I can tell better than the program so. Now, okay. But when there's one, yeah, friend. And you know, I say, I fancy I can't see for moto. Yan suppose I never dream back. Obi tita se mo bia enim se de obeya obe won se asem no say na ekwa na se edu ba bia yen cheche asem say abraba e boy edu ba because nikwa so obi from no tufo wa hwe no mai kona we wa system no tufo to hwe ne no mai koya nobody should tell you say we a political decision because Kevin Taylor vice president feel national security and the police airborne ho by Kevin Taylor in what capacity say Kevin Taylor bagana okota vice president fee adeba de Kevin Taylor bo Ghana I be mad apart from odi atem Kevin Taylor Ghana ni bonu bia nim say Kevin Taylor atem na odi but na dey atem dey nti no oba vice president feel den kokotena e born home sisi ya decision ya bai ofa me hwe ne transfer sisi ya investors confidence in the judiciary kura abeko from investors coming to Ghana confidence kura abeko from ko obetimi yesi against the judiciary na yesi ye jani say on confidence on kodia seriously that undermines the judiciary. That's why Mr. Temeka said nobody knows what is the rift between NDC and the judiciary. Sometimes Ed in so better say should the CCA can say CJ the Nefaso Chief Justice Imua should the Nefaso Ghana na Kevin Taylor national security for na born home by and so find that Ghana babun be and social media na by and when he answer back out na studio say na better to answer what the atem wow phone ya credit one city big so na to na wo di atem because assemble ye ba be fa kwotena bia obi anti fan in account next time no e be mbodi confirm o masa ayesa na asan so be ba politics dey come ofa ya hwe ya o man politics na be say no ya hwe ya o man politics na na be say no politics ya dey I say sekan etimi dey ya dey o kitchen ma dey nya aduane di ni anade but sa sekan na so no etimi dey awu I say ja fire is a very good servant by a very bad master. Ti I hear politics near now biaba no beye as and look at the way our costs have been packed. First nanka judge call retirement. Now appointee send an anako for the amount for call retirement or appointee. But it's not like that. This is a court of appeal judges be or money office cry and to say appointee become. Most of them are sitting as additional high court judges by an appointee and appointee become. And say last week 21.
Court of appeal.
Court of appeal judges
21. Asa beka home. Hey.
And President Mahama I appointed on my account.
So I'm saying Nanado su ponte court of appeal be bregu.
Na e be call retirement no appointee bi. At the babishim. But you 21. Judges court of appeal judges call retirement no. Omo 21. Omo 21. And no seriously, Pakistan a bear as I'm court. It's not a CJ or motion bossy. Then you account because the CJ is the one who's supposed to empanel judges for some of these things. Tia you free hold there or trying to just account home and the internet CJ as some no you who the kwana charges edible CJ. That's why I keep saying I don't get it. The road between NDC and the judiciary. What do you want to say? What do you want like we just mean crab for some better answer than wow. And then KELVIN TARLOR and the Ghana for an airborne hobby. So where the offer Munti case, Munti election petition case, Munti 3. Saturday ma Ubia Kotna Court institute to Kona Kasa. Now I'm sure because say one pass a pay a do court. And my who be bashe nipa manani pay ye by any day is a who free who to be candy ope. Not to be candy ope, Ubia nyohi, a bar, a bebo home by. KELVIN TARLOR may say. Enye asem we na aba nkono ho kwanso kota vice president fee. But look at the security the man protection the man. Ntia dey na me dey me go kan bi na me ma me protection no. Hwan em pa de pa.
Okay.
Adam dey me go kan bi ofa. Nti Ghana be be ko ne ahwe yi na dey policy dey president Amaka say oba akufo da parking to oba appoint NDC judges. Menim say Ghana ye court me who NDC judge na me who NDC lawyer ye kwa judges and lawyers in the court but and they chair say seriously offer say
okay that's it
some to bia where do you go for redress court I Mahama mfa Ghana court election petition Mahama mfa bianko akofo da mfa bianko say the court na e dey say dey na asem to offer minimum me other people na yeah they be fine
okay that's it lawyer Kwabra entry nketia e na watene nkan mame call na bo ekoko orabo
lawyer nensam na ya o kan obi wo ho a seri osika no wama obia obiti bia beka say lawyer soso no ase o ye politics too much ebi ene say ene de NDC for na eden emra na ede adwuma o seri wa o kan say the law suspended chief justice can say the law is the law enye nana ye de mra ye adwuma me bana metie ofa ya Canada Japan ono judge bi SIT no for contempt ena what call Supreme Court ena Supreme Court ye den ekwahye sa judgment no
de o man kwahye o
Bajo, ça dit man kwashe.
Man kwashe.
What's a contempt? A criminal offense. And also you can settle. Until the parties met and settled. It wasn't quite. And anyway,
say a kwashe you. Say almost settle you. The kusi ya ne say. Ye cited no for contempt of court no. Anko sifi. Sana mekano. Anko sifi. So settle ye. But what did not them? Anko sifi. And Canada Japan so what they call court. What they call court. Yes, bia assembly by no otna wa na anko sishi. What they call court. What they call court no and as attempted no aye odidi court. No kra de okeka no kra mpo yendimi nka no TV so. And someone nye bi ni KELVIN TARLOR de no. And someone ya okati ya judge no. Yentimi nka no TV so na say radio so kra. But at the end of the day, I'm going to see because I'm running a day. Some run on a day, you say, no, what can be said? KELVIN TARLOR, what the vice president, the FIA, and a national security in every protecting. But I mean, him say, and we are concrano, or cocoa tiemu, and who Maybe I may maintain, and I mean, who say. Quite our fast or who say, vice president, the FIA, and wotie no ofa na ese nka obusa no so kotwa mu vice president fie no hu se Kelvin Taylor fi ho ba na ya hu se national security for so e protect no na e kwa be no ofa so ya hu ye me fi se me allegation en se che gitumo ma dwene nyam se vice president fie no wotie dipa bi na e ka but I mere rumors Kelvin Taylor enye vice president fie no wotie and I mean kai se national security for so na protect no enye no kre afei case no a ya ye ka ho asem no unse ruling no enya mai but unse ne ye ka nyina ne se ampa ese se court bi bia anate judiciary no o mo hwe no mu ko ambefa so a ya pronisi o mu ebeye kwa ambefa so a ya o mu o mbenye authority o mbe protect o mu integrity say e kwa mfa so mo ye odwuma o mo makwan mu obi ntietia o mo so no mu mu o ma bonfia eno de se o mo ye sa de nanso abra ye o mo ye sa ni nyina so no o mo hwe se o mo ntie obi aso fa ahudie so enkanka fa ahudie a ya constitution ni de ma no se ba se edipa wo so aye bone na se wu bua na tan a ese se wutie no eno ho asem na no o ye lawyer na o ka ese se utie no na enkonko ye intenchia eno ane so usi nipa na ibone no wabu atan na wo de tie na abrekura ya wantie no abrekura ya wantie no constitution no ese emra no constitution no ese yenye de sa enti ese se ufre Kelvin Taylor na wutie no ansa na obebu na tan a wabu na tan
sentra bench warrant ne buy so omra na ntie
yeah
sentra bench
warrant no e buy no ekosi sei
so am
ben ubeda no hu so te se bench warrant bi ya dia mana na se fama lo ya mi busa Kelvin Taylor bench warrant no ho na de koma no o ba bia ya
I don't know o ka se bibia the social media so bibia si ya na
Ofa emra mesi ma me pito kokoko ewo adum ha se ya bra bi na me twam no o ka sem bi so no o ka ye no ono no de le ma no sa na obeka no ofa me nye lawyer but law no kaneno de no makwa me ye law ewo tech you know nti me my degree me won first degree ne law sociology BA law sociology no ka se bi na no ya o and o se ayi de court de o kwa emra ne yaka o enye no kure o se emra ne yaka ne o de ono le woman no ono na sa na se le man no na dwene ye ne se o court a emra e na o ka sa no kure sa enye no kure on de emra ne sa na dwene ye no na on de o ka but wo hwemu so a enye cha na tie se de emra no hu se no kure ne tie no ne ye adwuma eti na bi fu so se
ono ka no nchimo wo ne se what we are kase wo de ne no kure ba wantimi improve ewo court ma me de na o ka no eti no kase ho no wo se bu a kwa onim se na sem o ka na no kure ba wantimi improve court nye de o ka na
eti eno na sa sem no na me ka che
lawyer ba ti se na lawyer brenye kase ne no ya ma kwan se service no itimi ye no kwa hodo bebre so eti se ya se ona ko ka bibi wa ha na se court un se wakase eti omo no bi catch us se court hian na wankwa watomra
na watomra chete dia what you say
so obi
na supreme court for na e kase supreme court for no ena e kase
obi catch us say ya now so ha say
over de ya ka bi yan konkosi supreme court for no wo mo say yentimi enfre yentimi mfa kwan papa bi so enfre Kelvin Taylor ema no mai ema ne meyi na no eti ne wo mu di asem ne ma no sa na supreme court no ka enti dia wo lawyer obeka dia wo ofa obeka dia mi meka bi ya no supreme court no omo na mra no kura omo ene omo se yenyanya kwan papa bia ya ye fa so a ya ye frɛ Kelvin Taylor ma ne ba e ba beyi na no eni ntu no sa wonya kwan beyi na no yentimi mu and attain India no yentimi mu attain India no because yenya ma no kwan and I will say social media ofanyi obi an ko social media
no correct
so ati ase enti se bia asem no ba ye no se de maami kokowura yi kan emra ne ye kan wo de wo so social media obi a no ɛkɔ nti ohun ne ɛkɔ so ana wɔte ne ɛkɔ so but e bia na KELVIN TARLOR wante emra no so wɔ na fa sɛ e bia na asɛm no wante enti no sɛ wɔkɔ court no ka sɛ ye frɛ no ne ba ya wa ama no e bia na wante a emra no ɛse ɛsɛ ye ma no kwan na ɔno no obeyi na no ansa na ebuaten atia no na sɛ wo so wɔte vice president fie no de me ne lawyer anya dwene because on ko fie on ko hu sɛ ɛhɔ no wɔte na national security force na protect no so ɔno no wɔka mimi hunu sɛ national security force na protect no eti asɛm no ni na hwɛkye ne na wie nyinaa ne sɛ Supreme Court to say the entire ya KELVIN TARLOR ɔmo ka sɛ contempt no anasa CSC wabu court animtia na sa asɛm no ɔmo nyintumu anasa sa asɛm no ɔmo abaguo ɛne sɛ KELVIN TARLOR no abra ye ebu atɛn tia no ya ma no kwan amano ameyi na no ansa na yebu atɛn tia no ya ma no fair hearing ɛna wɔmo no court mu wɔmo wɔ in law no wɔmo wɔ nsɛm a ya wɔmo ka ɔno onim ni nyinaa onim ni nyinaa Ose odi otaram patem then
odi otaram patem listen to all sides.
Yes, listen to all sides.
So
listen to all sides.
To the other side.
Entino no na say Latin o sense die you. Omo de
Latin. Yeah.
Latin. Entino sanity. Natural justice. Just say as so utie both sides. Na meba na ye di nkomo na dey say contempt of court today who the court sa
we contempt we bench warrant
the de buy no contempt
okay
what you say
okay
the de buy no contempt the de buy no contempt ananya sa na tie